for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
So Katy Perry, it's almost getting to be where it would not be a radio law talk without some sort of copyright infringement lawsuit in music.
Yeah, y'all know what it is. Katy Perry, Juicy J.
This.
Let's rage. Your boy's been a Christian.
Oh, Denise is now dancing here. Oh my God. Oh, she's doing the robot, the funky chicken. Oh.
A lot of words that have tickled many ears. That's why I praise God for the word that we adhere. The word became flesh. Lived for 30 years.
I'm listening to this, trying to find the hook or the chorus.
So what you started off with, Cal, was the Katy Perry song Dark Horse.
Correct.
Right? And then did that morph into the second part was the
Flame and Joyful Noise.
Yes, the group Flame and Joyful Noise. And Flame, a Christian rapper, is alleging that Katy Perry has infringed by using the chorus of the song. Denise, explain a little more about what's going on.
Well, it's the beat that is actually being claimed that she took from Flame, and Flame is known as Marcus Gray.
Now, did she sample the beat?
No, it's not that. This is a very different type of an infringement case, because normally the infringement cases are the written music, the melody lines, where the chords go, certain riffs.
Mm-hmm. riffs, licks,
riffs,
chords, and structures.
Not riffs,
yes. Yeah, riffs.
And that's the normal type of infringement case. This case, he's claiming that she hook, line, and sinkered took the same beat from his music and used it for her chorus on Dark Horse. And it's really hard for me to distinguish.
How would you copyright a beat? Unless she directly sampled it off the record. And I mean, because that happens sometimes. Just listen to theirs, put it in a sampling machine, said, oh, let's use that, moved it over and directly used their work. How can you copyright a beat?
Well, if he has that, the drums and the stuff, and he puts it on a little tape and sends it in and copyrights that beat, perhaps that's it. It's not music, though. It's not written music.
Well, that's true. It's not. Now, copyright law has changed. We talked about the Led Zeppelin stuff before, and the issue in the Led Zeppelin case that we had talked about in previous episodes of Radio Law Talk, and you can find that in our podcast, dealt with the sheet music, because up until recently, to get a copyright on music, you had to have it transcribed, and the transcription, sheet music, was what you got the copyright on. Now you can file the actual recording as a copyright, which allows juries to listen to the recording and say, oh, this does or does not sound like that. It is the same. So this would probably fall into that purview, but it just didn't sound similar enough to me. If it was a jury of one, I think he would lose.
Jury of three.
And I couldn't get it either. Yeah, I tried to listen to it and I couldn't get it.
I get it, but you can't copyright like a backbeat. I mean, come on.
I know.
Come on.
Well, stay with us.
Yeah.
Stay with us. We'll come back.
So we're talking about the Katy Perry lawsuit. Led Zeppelin, during that lawsuit, they didn't allow the jury to hear the recordings of either songs because, again, based upon the controlling law at the time, the copyright was based upon the sheet music that was filed. So they allowed people to come in and play the renditions of the sheet music, but they didn't play the actual songs that we're hearing right now. This is the song. This is Spirit. Is that the name of the song, Cal?
Yes.
And
that's the name of the group.
Spirit, the name of the group, and this is the song that
Taurus,
that they claimed that Stairway to Heaven infringed upon. Well, again, they did it based on the sheet music at the trial, not playing the actual song, an issue that was later taken up on appeal. But in the Katy Perry song, in the Katy Perry lawsuit, they actually, they wanted to play the music for the jury so the jury could hear. What happened?
Well, Katy Perry's on the stand, so imagine I'm a juror and I'm a fan already, right? So she said that she and the other co-creators of her Dark Horse song. They'd never heard of Gray before, and they never ever heard a song, Joyful Noise. And so she says there's no way we could have copied it. And then they were going to play her song in court so she could identify her own song. And her attorneys were having technical difficulties with the equipment in court, and they couldn't get it to play. So Katy Perry said, I can perform it live for you right now. Can you imagine?
That would be interesting to bring in.
That would be so fun.
I just want to know who's running AV for a multi-million-dollar trial, and they go, I got nothing.
Yeah, sorry.
I can't put the button that don't work.
Yo, look, I usually hook up the red wire to the red input, and it's not there.
Your Honor, I don't know. Usually that's the purview. I mean, do you bring in your own stuff, or does?
Well, it depends on the courthouse.
Because the modern courtrooms, at least where we are, they got more audio-video stuff than a theater.
I can tell you, every trial that I have done where they have had the ability, and the court has these facilities where you can plug in and get everything done, every one I've done, the court has said, if you're going to use this stuff, it's up to you to come in early and make sure that everything gets set up. It's not the court's issue. It's up to you to make sure that whatever medium you have works with us. Here's what we use. Here's the inputs we have. So you bring something that's compatible with this. And that's what they work. Now, Denise, you raised something interesting, and I will confess, I don't know the answer. I know what I think feels right about it, but you said that Katy Perry said that we could not have copied it from them because we had never heard it before, right?
Yeah, we've never heard it before. We don't know this singer. We don't know of this singer. There's no way that we could have copied it.
So we never even heard of the artist before she was alleging.
Exactly.
Right?
And both her and the Truth testified too. The Truth is the other co-creator.
So let me ask this situation, hypothetical, all right? And probably not to use this one. Let's use something that sounds a lot more similar. Let's say we've got two songs that sound a lot alike, and then people would genuinely look at that and go, oh, this one clearly sounds like that one, okay? And let's say that hypothetically we can say that one party has never heard, the infringing party has never heard the other song before. Does the copyright protection that the first party filed still protect them? Because, look, we got two things that sound alike. Does copyright protection only protect against people that knowingly infringe, or does it also protect against unknowingly? And the difference between knowing and unknowing is, well, if it was knowingly, your damages are going to be higher. But if it was an honest mistake, cure the mistake, but you don't get to continue to go forward. I got two hands up. Cal, you had your hand up first.
I was going to say, I know in one case where the one, and I wish I could think of it, what it was. If you don't intentionally do it, the judge ruled, well, that's an obvious idea then. More than one person came up with it at the same time. Therefore, it's an obvious idea, so your request for copyright protection cannot be granted because other people are coming up with the same idea at nearly the same time.
Denise?
In this particular case, though, there was no copyright. You have to know that the Flame, he actually didn't copyright it, and it was available on YouTube, so it was out there in the public and available to be heard, and he could still claim copyright on, although he didn't formally claim a copyright. And I think in this particular case, since it wasn't in existence in a copyright but only out there to be heard, I think that's why in this case Katy Perry may win, honestly.
I remember back when I was taking communications in college, the professor in one of my classes talked about the poor man's copyright, which is if you create a recording, you pop that in an envelope and you mail it to yourself, certified mail, so that it bears the stamp of the post office.
And the date and time.
And the date and time, so you know that.
I've done that. Yeah.
He said to do that. A couple of the students did, and they got it back, and then they opened up the mail and pulled the thing out. And he said, "Well, you just destroyed your copyright. You have to leave it in there. You mark on the outside so when it shows up, you know what it is, but you don't take it out." But
unclear on the concept.
Yeah. Well, that's
so the issue in this case is just a little different. The issue was Joyful Noise was widely distributed enough that it became copyrightable, or is it too short of an infringement on the works that it couldn't even be copyright protected? So that's a little different than enforcing your copyright.
Would they look and see how many views to see if it was widely enough out
That's
there?
part of it.
Yeah,
They looked at the views on YouTube. And of course, Katy Perry's attorney is saying it's not widely distributed on YouTube. It hasn't been widely distributed.
Well,
so
and
you
look,
don't have the right.
And I'm just going to put on my skeptical hat here. If you track, and I'm almost positive that you would see this borne out, if you track the number of lawsuits that have alleged copyright violations, and you go back and you look at the original recording that the artist says was illegally copied by somebody else, I bet there's a spike in YouTube's views, if that's all that is, iTunes sales, if it was available on iTunes. Anytime a lawsuit like this is brought, it's going to increase the exposure of the older song. And sometimes you look at this as sort of a marketing ploy, but who knows? Who knows?
Go to the website, radiolawtalk.com. That's radiolawtalk.com.